So, good afternoon, everybody. Welcome back to this panel on migration and security. This edition of CPDP actually contains two different panels on the same issue. One focusing on, let's say, specific issues such as, for instance, security measures, the exercise of data subjects' rights, while this panel is likely to be more political. And this is why we have distinguished speakers. Mrs. Olivia Venet will introduce them. They are very well known. The description of the panel is very clear to you, and therefore we will discuss largely, though not exclusively, about interoperability, which inestricably links migration, police, judicial cooperation databases, and therefore there are some challenges in terms of some fundamental rights and freedoms by a data protection viewpoint. And we would like to see to which extent migration is directly linked to data protection, what the perspectives are, total information awareness approach about people crossing EU borders as appropriate solution to tackle migratory and security challenges. What are the costs in terms of individual rights? Are there any alternatives? And under what conditions certain data are to be used for different purposes? So what if we have to develop in practice the purpose limitation principle? So we may start by focusing on the last few years' experience. I think you may all agree that Europe has been facing serious challenges posed by the influx of refugees and migrants. This is on top of the political agenda. I stopped looking at the TV on my country of origin because every single hour they only discuss about migration. So there are also some increased security concerns, and they are heightened also by some terrorist attacks on our territories. So pressure has been growing to increase the capacity of member states and of the EU to reduce irregular migration, to ensure an effective and efficient border management, and to enhance internal security. In this context, the European Commission, today very well represented by Sir Julian, has launched several legislative initiatives. And some of them include the use, the reinforcement of certain large-scale databases. So, I think you are very familiar with the entry-exit system, with a view to record all entries and exits of foreigners crossing the EU borders, ETIAS system, which will require all visa-exempt travelers to undergo a risk assessment prior to their arrival on our borders. And therefore, it is perhaps inevitable sort of an extension of the scope and of the content of existing databases. I chaired the Schengen supervisory body years ago. At that time, Schengen First was a sort of a mix of compensatory measures following the abolition of controls at internal borders within the Schengen area. With Schengen 1 Plus, or Schengen Information System 2, we have a sort of a shift of the purpose gradually. We have a trend where we move from a control tool on persons and objects to an investigative tools. And therefore, new categories of information, new categories of biometric data, for instance, identifiers, including palm prints, DNA profiles may be now stored. I am a member of the judiciary. My background is on organized crime and anti-mafia legislation, as I said, And I think judiciary, police, public prosecutors, courts are to be equipped with the modern generation of tools. The question is what the best approach is. Is there any risk to have a common approach for every kind of information? Last year, the Commission adopted 2 proposals creating interoperability between police, migration, judicial databases, and they are part of a general trend to address the problems of migration and security in terms of joint concerns. And therefore, one of the concerns from the data protection community is that by referring in the same context to migration, internal security, fight against terrorism, then there is perhaps a risk of blurring certain boundaries between, on the one hand, migration management and, on the other hand, fight against crime and terrorism. So, question is, while the interoperability between police, migration, and judicial database might prove to be a useful tool, then there are some interesting, profound, and societal consequences. Someone has said this is a point of non-return. And these are all not technical choices. I think there are important political choices. And therefore, there are some ramifications for tens of thousands of people for a generation or more. And this is why it is of the utmost importance to have such a debate. I have adopted an opinion on interoperability to say that in principle we don't see any, let's say, conflict in between the 2 issues, data protection and interoperability. I'm in favor of a reasonable approach on that, but there are many, let's say, details to be discussed, and I'm sure under the fantastic role of Olivia, our speakers will focus immediately on what is best.
Thank you very much. I think you highlight the risks that we have to face and the debate that we must have regarding, for one hand, the number of data that we are collecting for the moment, and on the other hand, the joint concern and the fact that we are joining in our communication the problem of security, the threats of terrorism, and on the other hand, the issue or the challenge that we must face regarding migratory issues. I will now leave the floor to Mr. King, Sir Julian King. So he's Commissioner for Security Union since 2016. You have a very, very nice curriculum vitae. So I can say that you were UK Ambassador to Ireland in 2009, that you were Director General of the Northern Ireland Office, London and Belfast in 2011, Director General of Economics and Consular 2014, and also UK Ambassador to France in 2016. You are also Knight Commander of the Royal Victorian Order, and you will tell us a little bit more about interoperability now. So I leave you the floor. Thank you.
Well, no, thank you very much, and thank you very much for the invitation to come to this event. A security commissioner, a securocrat here with you. I think that's great. Some people have suggested to me it's a little bit like Daniel in the lion's den, but I'm sure you're going to be much more gentle than that. I want to say 2 things to start with. I've said on a number of occasions, but I will say it again today. I am absolutely convinced. I was convinced before I started this job, but all I've seen during the last 2.5 years has further served to solidify my conviction that effective security policy can only work when it is very firmly and visibly rooted in the full respect of fundamental rights. It can't work on any other basis because you will alienate people, including people who you need to work with, unless you can show that foundation. That's the first thing. The second thing I want to say is a little bit in reaction to your introduction. I'm going to talk in a moment about some of the practicalities that we're trying to develop on the security side, including interoperability. But before I do that, I want to be absolutely clear. We are not, in the Commission, in any way seeking to conflate the issues around migration and the challenges of dealing with migration on the one hand, and the issues relating to security, particularly some of the issues that have cropped up over recent years around terrorism, on the other. We absolutely do not do that. And please don't anyone suspect that we're trying to do that. To do that, to make that kind of conflation, is simply to serve the interests of, on the one hand, jihadi extremists who are trying to whip up fear and inter-community strife, including in our countries, and on the other hand, to fuel the reaction of extreme populists. And we are against that. We're absolutely not in the business of saying that somehow these things need to be put in one bucket together in terms of the policies that we pursue. Now, there are some security challenges. We've seen over recent years some horrible terrorist attacks. And we have sought to take some security measures to respond to those attacks. We've taken measures to close down the space in which terrorists and others who are trying to cause us harm can act by limiting their access to things like money, munitions, manpower, and indeed movement. To know more about where people are and who they are. And that was in response to the lessons that we drew from some of the horrible attacks and what those on the front line, particularly law enforcement, but also border and guards and immigration officers, were telling us that they were drawing as lessons. We found that there were some weaknesses in the way information was being shared and the way it could be accessed at the moment within the rules. And we had a lot of feedback from those on the front line that if there was anything we could do to help them within the rules to get more timely, speedy, and accurate access to information, that would be really, really helpful. So we set out on this course some years ago now of seeing whether there was something we could do to answer that need through what has become known as interoperability. I want to say very briefly something about how we went about doing this policy work, and then a little bit about what it is. So how did we go about it? Well, first of all, we listened, as I said, to feedback from those on the front line. But then, precisely because we realized that there would be sensitivities around trying to make progress in this area, we determined from the outset that we were going to do this in a very open, transparent, and inclusive way. And so, and thanks to both of you, I'm surrounded by two of the co-authors, in effect, of elements of interoperability. We, from the very beginning, as well as working obviously with the member state experts, and with the European Parliament, the Council, we involved you, the European Data Protection Supervisor, and the Fundamental Rights Agency from the beginning. And you, Giovanni, and you Michael, were yourselves and your representatives involved in every stage of this work. So we started with some experts talking through the issues. We drew some conclusions from that expert exchange. We made some proposals in the end of 2017. We were absolutely clear in making those proposals that, in our view, they were fully in line with the Charter, GDPR, all the other relevant law, and that in taking this work forward, we would have right up there the need to deal with the data protection issues in a way that was proportionate, legitimate, balanced, etc., and that you were steering us in pursuing that. We have negotiated those proposals with the Council, with the European Parliament, and we are now in the process of, I hope, drawing to a close the trilogue, the reconciliation process. In those negotiations, you will not be surprised to hear that both member states, but in particular the European Parliament, drew extensively on your reports. Because not only were you involved in this at the beginning, you were involved again at the end. You then marked your own homework having helped us to formulate all of this work, you then wrote a report for our EDPS on how it had come out. And those reports have been key documents for, in particular, the Parliament, but also the Member States, as we've been trying to improve, reinforce, and reach a conclusion. So the first thing I'm quite proud of this. The first thing that I want to say is that I think this is a model for working on sensitive issues like this. And I hope, whatever else we get out of this, that we've established an effective model that can be used in the future as well for trying to deal with these sensitive issues. So what have we got? Well, I find it helpful sometimes to clarify what interoperability is not before saying what it is. It is not about collecting new data. It is not about merging individual systems or putting all data in one big pool. It's about using existing information held in the systems that we've agreed, including with the Council and with the Member States, in a better way, in a more targeted and effective way, while taking into account all of the rights of the data subjects concerned. And that's what we're doing. These proposals are based on data processing being limited to what is strictly necessary and proportionate, in line with the existing rules, in particular the existing purpose limitations. There's no new kinds of information going to be collected for the purposes of interoperability. Interoperability works with the existing systems and the existing rules as they are agreed by the Council and the European Parliament. Interoperability is not about profiling. Indeed, you can't profile on interoperability. It doesn't provide any profiling tools. It's not about any form of discrimination on any grounds. Sex, racial, ethnic, religion, disability, age, sexual orientation. You don't have the ability to do that with what we are proposing. We are proposing four technical steps for making access to information that exists in the databases work differently. First, a search portal, a European search portal that would enable authorized users to carry out a single search and to get results from all the systems that they are authorized to access, rather than having to go through each system individually. But we're not changing the rules on what they can access. We're changing the means that they can use. A shared biometric matching service, which sounds a bit scary, but is actually a search engine. It will allow users to search efficiently and cross-match biometric data which is stored in the respective systems. But it doesn't collect any more data. It only works with the biometric data that is stored within systems according to the existing rules on the bases that have been agreed by the Council and the Member States. But that will help you to have fast, systematic and controlled access to information that you need to do your work. In particular, one of the lessons that was thrown up by a number of the attacks was that a number of the perpetrators were circulating with multiple identities, fraudulent identities. And we have an issue with identity fraud, and we have problems with dealing with it as things stand. That is the direct feedback from those in the front line. So we proposed, third element, a common identity repository. Again, sounds a bit serious, but as you know, because you've been involved in the discussions of this is actually a way of accessing basic biographical and biometric information, names, dates of birth of non-EU citizens, so that they can be reliably identified. The identity data continues to belong to the respective underlying systems that recorded the data. And all the rules and all the safeguards of those systems continue to apply. And then fourth element, we proposed a multiple identity detector, which allows you to check whether the biographical data searched for exists in multiple systems. So that means you're not interconnecting all of the individual systems, but you are allowing access to core identity and fingerprint information held under the existing rules so that we can ensure that an individual cannot be registered under more than one identity. At the moment, we're not able to do that. And that is a problem. But with this proposal, authorized officers would get an automatic warning against a potentially fraudulent identity when they check someone against a database. Now, I hope we're going to get agreement. The final trilogue, what I hope is the final trilogue, is coming up at the beginning of February. If we get agreement, it will take some time to roll out these proposals. We will need to accompany the member states and the agencies involved as they roll these proposals out. And again, I hope you will do this with us. I hope we can do it together with you, the EDPS and the FRA, to make sure that the implementation respects what we're trying to do. And once it's up and running, we're committed to review how it works with a special focus on fundamental rights, and we will report publicly on that. So in this, as in the other things that we've been doing on the Security Union, we are absolutely committed not only to respect fundamental rights, but to be seen and to show that we are doing that. And we're committed to working in a joined-up partnership with both my neighbors.
Thank you very much. I was very happy to see that you wanted to make this difference between the security and the problem of terrorism, of course, and the problem of migration. It's very important that we make this difference, but I can still see that interoperability is a way of accessing databases that are concerning migrants and crossing borders. So not only we have to make sure that the rules and the law and the safeguards that we put show this difference and do not join those two topics, I won't say those two issues, but those two topics, we have to make sure of that, and we have to make sure that we show that. It's also a question of image, because we have to communicate on those issues. So that's the first thing, but I'm sure I will hear other speakers about this. I wanted to also highlight that there is a very important thing, it's the purpose of the data. So that's really the issue that it's at stake. Data should be collected only within a specific purpose and a limited purpose. And of course, interoperability will affect the purpose itself.
We reckon, well, we may differ on that. We reckon we're respecting the existing rules in what we are setting up here. Only those who are authorized to have access to the information for the purpose that was collected will be able to do that when it comes to interrogating the information in detail.
Okay, I understand what you're saying, but I think that when the data is collected, the data should be used and collected only for a specific purpose. And by creating the interoperability, we will blur the difference between those different purposes.
No, but we've agreed the purpose in a way that is compatible with interoperability in each of the instruments agreed with the Council and with the European Parliament. So interoperability doesn't change things that are being agreed in the underlying systems.
Okay, thank you. I'm sure I will hear other speakers about this also. I will now give the floor to Mr. O'Flaherty, and let me introduce you very shortly. So you are the director of the EU Agency for Fundamental Rights, and you are also a professor for human rights law and director of the Irish Centre for Human Rights at the National University of Ireland. You were from 2004 to 2012 a member of the United Nations Human Rights Committee, and you've also held several posts at the United Nations in Bosnia-Herzegovina and also in Sierra Leone. So I think you can share with us your expertise on human rights, and I will give you the floor right now.
Thank you. Thank you very much indeed. And thanks to EDPS for hosting this event, which I think is very welcome. Thanks to Commissioner King for more or less saying what I was intending to say. But I really welcome the model the Commissioner spoke about. He described it very accurately. I would like to see it transposed in many other policy areas. Of course, the impact of an agency such as the Fundamental Rights Agency in terms of the outcomes still has to be seen. But the model itself is a very valuable one. I also strongly endorse and welcome what the Commissioner said about the relationship of human rights and security. Human rights compliance security is better security, as he said. I also know from my own personal experience. For instance, the Commissioner and myself overlapped in Northern Ireland, where a human rights commitment to the security strategies in the period when I was there, and if I may say so, when you were there, was the bedrock of their success. The investment in working with communities, in focusing on integration as much as on hard policing initiatives was what made that territory in those times a secure place. But let me say from the other side of the human rights security communities that we also get that strong security is vitally necessary and it's entirely attainable with respect for human rights. In terms of the respect for human rights, a few general observations, and then I'll get to the specifics of the current interoperability proposals. And the first of those general observations is that it's important to keep in mind that the human or fundamental rights security relationship is not about some kind of zero-sum game. It's not about how you have to show respect for human rights, you have to concede a little bit of security, or vice versa. It's indeed, as we've already said, it's quite the contrary. And the spectacles of human rights open up areas that can be paid attention to in a security context that might otherwise be overlooked. And the particular relevance of that remark this evening is that security cannot just be about data. Data has its values, but so much more is required for effective strategies. And so let's not, and I'll use this word, it's crude, but it's not intended in reference to any institution or anybody on the panel, but let's not fetishize data and the interoperability as being the be-all and the end-all of the security interventions. Let's also keep in mind, and it very much follows on my earlier remark about the relationship of security and human rights, that the human rights system itself, the legal framework, whether it be the fundamental rights framework of the European Charter or the general human rights protections in the relevant treaties, it's quite a reasonable system. It rarely insists on the absolute protection of a right. It acknowledges that rights can and must be limited, so long as some fundamental tests are employed and respected. Above all, the tests whereby the right is only limited where it is absolutely necessary, where the extent of the limitation is proportionate to the good that's being served, and where where all the interventions avoid falling into the trap of discrimination. Now, it's these attitudes and the principles such as those that inform how the Fundamental Rights Agency has engaged the current interoperability discussions in the European Union, both in terms of our research and our formal opinions, such as those the Commissioner has referred to. And so let me reiterate a few of our primary issues in this context, in this late stage of negotiation, in the hope that they will be taken due account of. And the first, of course, is a positive one, if I may, which is that interoperability can, and people are sometimes surprised to hear me say this, it can deliver powerful goods beyond security. A well-functioning system of interoperability, for example, can help us in tracing missing children. It can also help establish the identity of people without documents in certain circumstances. Obviously good things. But as we seek to deliver on such good things beyond, including and beyond security, we do need to make sure that we hardwire the commitment to data protection and fundamental rights in the very systems themselves. We have to have explicit reference and explicit machinery to ensure that a gaze is always maintained on the human fundamental rights and the data protection dimensions or impacts. Secondly, and indeed it's the point you made just now, our moderator made the point on purpose limitation. We also recognize the extreme care that will be needed in the frameworks to ensure that the principle of purpose limitation is respected. I've heard what you said, Commissioner, that purpose limitation will be honored such that data cannot be interrogated by the wrong people for the wrong purposes. But we want to make sure also that mischief is not created by that, let us say, a police force becoming aware of the presence of data in a certain database, which is not one required or gathered for police purposes, even if the police cannot interrogate that data. The very fact of the awareness of the person's name being there could already trigger unfortunate outcomes. We are also concerned that the final package will avoid an overreach in terms of whose data is gathered in the first place. We're not convinced right now that the extension of the VIS database to not only visa seekers but long-term non-citizen residents is actually required. When we're talking about long-term residents, people who've been decades in a country, we are very often not talking of somebody with any particularly greater security dimension, security risk than somebody in the general population. So why the distinction? And indeed, does the extension to the long-term residents suggest that in some future iteration of these packages, we might indeed find that the 500 million of the general population are somehow also caught up into the systems and therefore accessible in the interoperability context. Moving on to multiple identity detection, we obviously get the extreme security value in having an effective system of multiple identity detection. But we would urge that we avoid drawing the wrong conclusions from the detection of multiple identity in a particular case. It is not axiomatic that an individual will be shown up as having multiple identities because he or she is a criminal or because he or she was engaged in some sort of fraudulent activity. There are legitimate reasons for multiple identity, such as, for example, where somebody marries and changes name. And also where somebody, unfortunately, has arrived in Europe in a context of having very poor quality civil registration back in his or her home place, which again could trigger multiple identity issues. So we see the value. We just ask that great caution be taken in terms of drawing conclusions from such issues. We're anxious to make sure that children are properly taken account of in the context of interoperability. According to the United Nations Convention on the Rights of the Child, an instrument ratified by every EU member state, the only engagement with and for and regarding children should be in the best interests of the child. And again, it's important, we're not suggesting that anybody's working contrary to this, but it's important that this quality be captured in the package. And we would also remind that biometric data is very problematic in the case of children. Facial features not yet fully formed, fingerprints not yet fully formed, and we have to ensure, in whatever outcome we have, that this is taken account of. And that brings me then to my very last observation in this round, which has to do with flaws, mistakes. We've been taken aback, frankly, in the Fundamental Rights Agency in our research at the extent to which we find error in the databases which will be rendered interoperable. For example, we interviewed a large sample of people responsible on the European frontiers for the entry of information into databases. And more than half of all of those interviewed said that either they personally had committed mistakes entering data or they had detected mistakes in data with which they were dealing. And so that's not an objection to interoperability, but rather a caution as to the checks and balances to ensure that data is interrogated correctly. And it's in that context that we welcome the discussion of a so-called traffic light system, albeit we'll have to see it in operation in order to test its effectiveness, in particular with regard to which data is registered as orange and which as green. But nevertheless, the initiative is a welcome one. And so we look forward very much to seeing the outcome. We only have an advisory function, and so therefore we wait with everybody else to see to what extent we've been persuasive. But we do also recall that we're persuading on the basis of fundamental rights law. And so ultimately, the test of the package that's being negotiated will be how it fares in the regulatory context of the data protection supervisor and the jurisdiction of the European Court of Justice. Thank you.
Thank you very much. Thank you for referring to those specific words, the framework that we should be in it, the necessity, the proportionality, the purpose. I think it's very important within a vision of human rights or fundamental rights to make sure that we are in a legal framework that it's compulsory and that the safeguards make sure that the system can never be used without, and even with irreasonable person, without those safeguards. You mentioned also the caution, and I'm sure that the next speaker will highlight this, the problem of the mistakes in the data and the caution that we have to have regarding those data. So, Mr. Van Gemert, you are now Deputy Director of Europol and Head of the Operation Department. You manage the Department of Expert Specialist Analysis dealing with serious and organized crime, as well as terrorism and cybercrime. I leave you the floor right now.
Well, thank you very much, and let me start by saying that I'm very grateful to have the opportunity to speak in this panel, but also to voice more or less the law enforcement part in here, and especially also the view of Europol. I think my role is to focus a little bit not so much on what's coming, but on what we are doing. How do we operate for now with the possibilities that we have on this issue, but also what would this mean for the future when interoperability is even more in place, and how, as Europol, we would be looking into this. So I think most of you are aware that within Europol we have the Europol Migration Smuggling Center, in which we look at migration, but especially not from the field for migration, but from the field of organized crime behind immigration. And we have guest officers deployed in Greece and Italy, coming from member states in which we do secondary security checks. And I will explain a little bit later on how this works and how this refers to data. But first of all, I want to make also a statement, making clear that also from a law enforcement perspective and from our tasking, being confronted with migrants and with the, let's say, the way that they are being treated by organized crime, we are very cautious about the impact that we have on individuals and how our work could influence people that are coming in a new situation, not speaking the language, fleeing from terrorism, and then being confronted with us or with law enforcement in this field. And having said this, I also want to discuss a little bit on the debate that we have, because what I hear when this is being discussed, that there is always a discussion on the balance between data protection and security. In a way that we discuss this when we improve data protection, security goes down, or when we improve security, data protection goes down. And I don't believe in the zero-based sum. That's not the reality, and I would like to go away from that balancing tune, more or less, and look into the different ways on how you could look into this. Because I don't think it's a zero-sum trade. I believe in the fact that you can turn up security without turning down data protection. But it is also true, I think, that turning up security in that way would also, well, or let me say, just decreasing data protection and data security not always leads to an improvement of security. So this is something we have to look into from a different view. I'm not saying that there's no relation and there's no impact between those, but it's not the case that it's always, if you upgrade the one, that you downgrade the other one. So I think looking at that point of looking into security and data protection, we would like to look in it from the point of view that data protection should be part of our systems. So I would like to introduce the concept of data protection by design also for law enforcement, and probably also in a specific way for law enforcement, different from other forms of doing this. So having said this, now more towards how does it work? What do we do? What kind of activities do we deploy? Are we deploying, and how does it affect people? So first of all, we have indeed at hotspots guest officers. These are officers coming from the member states under responsibility from Europol, and they're doing secondary security checks, as we say it. So they're not at the border checking everybody. They only, operate on request of a member state, so Italy or Greece or any other country, if there is a reasonable ground or indications for possible threat. That's the reason for coming into this request. And they are there with our mobile offices and having the possibility then on this kind of reasons to check the databases that we are allowed to check in a legal situation in there. In that way also offering support towards the member states to make sure that if there is any indication for organized crime or for terrorism that we would be able to indicate this. Just to give you an example, last year almost 1,500 times this kind of request was made towards us. And it can mean that one person is checked, but then probably is also a phone and a story or an identity. So more items can be checked, but this is the way of looking into this, this issue. And it ended up with more than 400 cross hits, as we call it. So a hit in which there was a reason to check more because there was something in our database. So it's not on the first instance that we take that role. There has to be a ground, a reason for doing something extra. The other part is on migration. And as I said before, I think we are not looking into migration from the migration perspective. So we are also not collecting data on migration. We are trying to collect data on those who are responsible for organized crime behind migration. And it means, to give you an example, that sometimes when there are interviews with migrants, we don't get the full data, but we only get, let's say, the data that would be interesting for us. The roots, the backgrounds, the phone numbers of those who have been contacted by them. This is the information that we are looking for. So we're focusing on smugglers, and we're focusing on potential threats, terrorism of other forms in there. And then by doing so, I would like to ask you to look at also from a different perspective. In trying to identify only that small part that we really have to look in, we're also protecting, in my view, the idea that every migrant or every person would be needed to be checked, because that's the feeling that could also arise in our society. So that's something, an aspect that I don't hear too much. Indeed, I think databases are important for us. Are they the most important issue? No, that's not true. I think they can be an accelerator. They can also be very useful in an investigation. But an investigation is always more than only checking on data. What do we do now? What kind of information are we able to process as Europol? Well, we have access to SIS. We have the Visa Information System. And we have a very limited access to Eurodac if needed and if there is a legal ground for this. In the future, with the interoperability agenda that Sir Julian King just mentioned, there will be more possibilities, but all in the same access right as we have now, unless if there is a legal change in this field. And looking into this, I would like to bring some principles forward that we also as an organization try to bring, to have this as our, let's say, our vision towards when and how to use data. First of all, there has to be a clear relation between the topic and the database that's related towards this. More or less the mention that you mentioned, the reason you mentioned also. It's not the first thing that we do. There are also other means that we have to invest in to make clear if there is a reason to even step up and go into a database. When you do so, you have to do it in a less intrusive way. So making use of techniques that are now available, in which anonymization is a way to check if a person is registered in a certain database. But even by doing so, it's not about getting the total hit database, it's on a hit, no hit basis. So if there is a hit, is there no hit, then there's no reason to go on with this. And finally, and it's a very important thing, we are also, and that's also my personal motivation, we are serving the community. So there should be an oversight and control that's being organized. But when this is organized, it's also our legal task and our responsibility to do so, to protect our society. And there is a lot of oversight at Europol, to be honest. We have our own data protection officers here present in this room. We have our own audit office that is auditing our processing ways. And we have the external oversight by the EDPS in that way. So information is an asset, but it's not The only thing, if the asset is not of high quality, then it's not bringing anything. So the second part of the assets is the quality of the information. And that means that we have a responsibility to keep it at that high level, and that's also, I think, that what we try to do in our systems. At the same time, I think we are also requested to make use of all technological developments. And also our regulation that only comes from 2017 gives us the opportunity. It's a technology-neutral approach that we have, in which we also included privacy by design. And it was also included by the legislator in this field. And more or less, even before GDPR, we have more or less a similar setup in there. So what does it mean in our processes? So there is a purpose limitation, first of all. There is transparency on who is using this. There's retention on the information in our databases. There's the liability and access control. And finally, there's the security of the data that we have to take part of this. And all of this is, I think, and as been said by the Commissioner, condition sine qua non. So it has to be there, because otherwise it will not work. So I want to make clear that data protection and data quality are also in the interest of law enforcement. That's not something that we are against. On the contrary, I think we benefit from this point of view. And the last point, just to talk about oversight, I think even by the oversight committees I mentioned, there is an extra one. That's the parliamentary scrutiny group that we have in our regulation, in which both the European Parliament and all national parliaments are present, and they also have the responsibility to look at this. So if Europol is about protecting Europe, I want to make clear that that includes also protecting fundamental rights in there, and it's part of the way that we try to operate. Thank you.
Thank you very much. I think that gives us a very practical vision and also a very concrete vision about how to fight smuggling of migrants. And I, of course, really appreciate that you don't want to make a balance between security and freedom, but get both. And I think we are entitled as European citizens, but also as human beings, to have at the same time security and freedom, of course. But I will leave the floor to our four speakers because we don't have that much time. And we'll have a more academic point of view with the Dr. Sergio Carrera, Senior Research Fellow and Head of Justice and Home Affairs Program at CEPS. So I will leave you the floor right now. Thank you very much.
Thank you. Thank you very much. To start, thanking the EDPS for the invitation, for the kind invitation. It's an honor to be in this panel and to contribute to the debate on interoperability. And the contribution I wanted to highlight or to bring in the discussion relates to trust and mistrust. So the extent to which interoperability is trust enhancing when it comes to national authorities and individuals. And of course, I'm coming from an experience of about 18 years following as an external observer the work of the European Union on databases. And this is a story where one has the feeling that EU and national principles, rule of law principles, very basic rule of law principles, but also better regulation, are sidelined or completely disregarded. So we have, we've had wonderful contributions and evidence brought by academics, by the EDPS, by the Fundamental Rights Agency, highlighting what the issues are, and while they are taken into account somehow, they don't really have an impact in the outcome. Meaning there is this logic of sort of inevitable. It's something that was mentioned before, a sort of point of non-return, that we cannot change the very idea. And I think we should come back to the idea itself and have a proper discussion about it, about the necessity of interoperability and its proportionality. I mean, it is difficult even for an expert to understand all these EU databases, the new revisions. So for the public, I can imagine this is completely incomprehensible. It's mad. If you just see all these EU databases and everything that has happened so quickly, frankly, I don't get it. And I should get it. I mean, I'm working on this. Now, in terms of substantive arguments, there seems to be this idea that fragmentation is a bad thing. And perhaps we need to think about it more carefully, because fragmentation may reflect necessary checks and balances, domestically, constitutional checks and balances between different authorities having different competences. Very well-established communities that have separate mandates. So the police has nothing to do with asylum authorities, and there is very good reason why. So compartmentalized structures make actually a lot of sense. And one wonders, really, if interoperability would actually help in effective policing. This has been mentioned before. There has not been independent evidence showing it. I haven't seen it. One could think of the wider the circle of actors, sharing information, the less trust those actors will have as to who has access to that information. The more mistrust as to who is going to have access to the information and feeding into this system. So I'm not really sure that interoperability helps trust for national authorities, not only police, but also judges and also communities dealing with asylum. Not least the question of independence. Who is a law enforcement authority? And we have several member states backsliding on rule of law, where independence of judiciary is a key issue. How can we prevent that this data is not misused for political purposes? And the second argument comes back to data, quality and access to remedies by individuals. To me, this is a very big problem. We have evidence by the FRA, it was mentioned before, under Watchful Eyes report, showing that there are errors. Baseline quality is very low in existing EU databases. Now, we don't have really effective means to ensure that unlawfully gathered data is not misused or even used. This fruit of poisonous tree doctrine. How do we ensure really that the data is lawful? What are the means for that? So would interoperability magnify those issues? Like make them even more, problematic? A magnifying glass of already existing problems, errors in data. The FRA has very helpfully, I think, highlighted how more often than not, individuals lack awareness and understanding of what needs to be done in case of mistakes in the data. So is interoperability going to do things easier for individuals, and particularly vulnerable groups? We are talking about asylum seekers and refugees. Have we thought carefully about the impact of this for people who are seeking international protection? And it's really striking, the new regulation of the EU LISA agency has been adopted also like this. Even before the proposals on interoperability are adopted, and it has very weak, extremely weak safeguards for individuals. The FRA was suggesting an EU-wide request handling mechanism, which I think is a wonderful idea, but which is not contained in the new regulation of EU LISA, in comparison to the new Europol mandate, which is quite robust. In terms of complaint mechanism, EU LISA has nothing. And EU LISA is usually dressed like the technical is technical, they do nothing, but actually the new regulation gives this agency very important powers, not least quality management of information, which brings me back to the previous issue. Now, discrimination, I think, still is a problem. By allowing access to everyone under the sun to data of asylum seekers, we are putting a veil of suspicion on asylum seekers and refugees, and I think this is really worrying. Mixing up crime with people seeking international protection is unethical, and I'm speaking here as an ordinary person and citizen. I think this should not be done, simple as that. But it appears to be the logic. And I come back to, as my final point, on EU policy making in this area. So in the name of crisis, in the name of the refugee crisis, the ETIAS was adopted. There was no impact assessment whatsoever on the need of ETIAS, necessity, proportionality was adopted. The entry-exit system also has been adopted. The EU LISA mandate has also been adopted. You know, I come back to the story of inevitability. Is this inevitable? Is it senseless to have this discussion today? Because, frankly, again, as a citizen, I'm really concerned that we are not paying attention to all those things, and they may end up in wrong hands. They may end up in wrong hands. We've had, you know, not recent history of misuse of data, and this is too tempting for the radical right. It is simply too tempting. And the notion itself is volatile of interoperability. So now we can be concerned of safeguards and fundamental rights, but in itself, it will be a technology that may be adapted to whatever purpose or political purpose may be in the future. So I really will hope, as a final note, that the European Union in the field of security has a realistic contribution in this field, and that we don't raise expectations that we cannot meet, and that also we involve citizens, and we have not just the formalistically that fundamental rights are protected, but how precisely? How are those rights accessible to people? How do we prevent misuse? And at the moment, this is an open question, very big open question for me. Thank you.
Well, thank you very much. We have a very few minutes to take some questions, even though I think Mr. Carrera just raised some questions that the other speakers, and I'm thinking especially about you, Mr. King, could answer, if possible. But if the floor, if the room wants to ask one question, maybe we can take one or two questions if there is. If someone is interested, if they can raise their hands. But if not, I will, following on what you just said, and asking Mr. King if you can tell us a little bit more about the debate we think, well, I think we should have about how the safeguards that are put in place make sure that human rights are protected, even if the database fall in the wrong hands.
Well, I probably haven't got time to answer all of the statements that were made, but let me try and address some of them. This idea of inevitability, which creeps into the discussion sometimes, or that there's somehow a point of no return, seems to me to be a bit odd, with respect, because it suggests that there is no democratic check and balance at play. And yet there is. The systems that you refer to and the proposals that we've been talking about on interoperability are not something that I or anybody else sort of magics up in a dingy office somewhere and then just rolls out. These are legal instruments that have to be adopted according to all of the legal rules and practice of the European Union. And I'm glad that the European Union is a space of rule of law. And these systems exist in that space. They can only be agreed by the co-legislators. They can only be agreed when they're agreed by the Council. They can only be agreed when they're agreed by the European Parliament. And as we've said, in this particular case, and I think it is an example that we ought to look to expand into other sensitive cases in this area, all of that work has been done, advised by, monitored by, with contributions from the FRA and EDPS. And indeed, in the trilogue process that, as I say, I hope is coming to a close now, a number of things have been clarified, reinforced, inspired directly by that external advice and scrutiny. So the protections of children, for example, are going to be strengthened. It's not that they weren't there, but they weren't as clear and on the face of things as they might be, so that's going to be strengthened. The rules around complaints and recourse of data subjects are going to be strengthened. And these are issues that were raised throughout the process, but again in the reports that we've taken into account in trying to get this legislation right. But the fruit of those discussions then has to be agreed by the European Parliament and by the Council. So, and that's true for every change. So I have some trouble with this idea of historical inevitability, because it ignores all of that. We can't change anything without that process being worked through. Then there's one other thing I wanted to comment on. This question of misuse. Now this comes in two forms. It comes in a, I won't call it paranoid, but it comes in a particularly dramatic form, which is that somehow somebody is going to seize control of these instruments or these databases and completely subvert them. Well, that's not the EU that I recognize. That's not the legal framework that we exist in. These instruments are founded and rooted in the whole legal framework, rooted in the Charter. There are individual cases, slightly less dramatic. There are individual cases where there is some dispute about whether an authority, perhaps a national authority, is using an instrument for purposes other than the purpose it was intended for. There's a recent case which attracted quite a lot of publicity around the Schengen information system. I take a different lesson from that than perhaps you do, which is that if somebody does try in an individual instance to abuse one of these systems, it is in fact extremely difficult to get away with it without an enormous amount of publicity and scrutiny. Because the checks and balances are there, because it's transparent, because it's a legal order, anybody who seeks to misuse an instrument, like arguably the SIS alerts, will be crucified publicly.
Okay, maybe
If I
please.
may, you mentioned many times EDPS. Thank you for these references. I think it's difficult to make conclusions today because I noted a fil rouge concerning interoperability, but also specific concerns and specificities. Perhaps the best way to approach conclusions is to say first that interoperability doesn't seem to be, let's say, unification of different databases. We are speaking about interlinking, and therefore, question is not why interoperability, but perhaps which interoperability. The second concern relates to the kind of precautions we are going to follow. As independent data protection regulators, I think we should be a little bit flexible with regard to the assessment of the purpose limitation principle in similar areas. I'm speaking about entry-exit systems, visa. Perhaps the assessment could be more flexible, while should be, in my view, much more rigorous when you are speaking about administrative data on the one hand and data concerning individuals who are not suspected of committing any crime. And this is why, in our opinion, and this is why we launched the idea to have such a political debate, we insisted in focusing on the need to specify, to separate what we call primary purposes and secondary purposes. In each country, subject to specific rules, law enforcement bodies, the judiciary may have access to certain data. What is essential is that we do not merge everything and we say that everything should be let's say, launch for the same things. So the current situation of a fragmentation of such a galaxy of databases created in different periods on a basis of different legal frameworks and for different needs is not sustainable. But what is essential is that we now look to the future, building on this experience, and we make profit of these concerns.
Thank you. I think we would have liked to have more answers, and I'm sure Mr. Carrera is really frustrated now, and maybe you too. But unfortunately, we have no time, so I thank you all very much for your contribution. And thank you to you.